Welcome to the latest UCL Centre for Criminal Law event. We're delighted to welcome Kent Roach, a very distinguished professor from the University of Toronto, to speak about comparative approaches to the study of miscarriages of justice in light of the English experience. I'm not so sure whether the English experience is a euphemism for how not to do it, but we will see when Kent presents his paper. After Kent's presentation, we will hear comment from a stellar panel of experts on appeals and miscarriages of justice, beginning with Henry Blaxland, King's Counsel from Garden Court, and then we'll hear from Dr. Jon Robins from Brighton University, and finally from Dr. Hannah Quirk at King's College here in London. Let me introduce Kent Roach more fully. He's the Professor of Law at University of Toronto with a distinguished record in research and publications on criminal justice. Many of his 16 books and 275 articles deal with this topic of miscarriages. And his influence on Canadian law and justice is also clear from his direct involvement in public inquiries, including those into miscarriages of justice. He's a fellow of the Royal Society of Canada and a member of the Order of Canada. And we're delighted that he's here speaking to us this evening, albeit remotely, owing to personal circumstances. And this is, as we were just discussing amongst us as a panel, such a timely discussion, given the English Law Commission is currently reviewing the appeals system. The Criminal Cases Review Commission seems always to be under close scrutiny. And there's a general concern that the current acute resourcing issues in England and Wales are generating ever more miscarriages of justice. It's a good time, perhaps, to step back and consider the problem and what others in other jurisdictions are doing to tackle that. Kent, welcome. Perhaps we could hear from you before I invite comment from our panel.
Well, thank you very much, David, for that generous introduction, and thanks to everyone, Mark and others at UCL that has made this possible, as well as thanks to the panelists and for those of you watching. I apologize that a family health crisis has prevented me from attending in person. My talk tonight is part of a larger project on the comparative study of miscarriages of justice. Why study miscarriages comparatively? One glib answer is that as a Canadian, you are a comparativist because you live next to the US and in the shadow of the UK. But more seriously, I think the comparative studies of miscarriages of justice is understudied, neglected, compared to, say, the related topic of comparative death penalty. I also think it's a practical mistake because of a migration or transplantation of reforms, often taken from England and then spread to the US and to other jurisdictions, including Canada and New Zealand. The US-based Innocence Project has invested in developing an international network of innocence projects. The leading American scholar of wrongful convictions, Professor Brandon Garrett, has been using comparative law in a tried and true manner. In 2017, after a sabbatical at Oxford, Professor Garrett published an article, Towards an International Right to Innocence. It depicted a common consensus of practice across a wide range of jurisdictions, including Western democracies, but also China and in India. More recently, Professor Garrett has published an article in 2021 with two colleagues towards which calls upon this common practice to be translated into an international right to claim innocence post-conviction. That would be a parallel to Article 14.6 of the International Covenant on Civil and Political Rights, which you are, of course, familiar with. Those who argue for an international right to claim innocence rightly point to the manifest injustice of imprisoning the innocents and the inevitability of wrongful convictions. They also point to a well-developed knowledge about the common causes of wrongful convictions, including eyewitness identification, testimony from incentive witnesses, bad forensics, etc. Although I have the greatest respect for Professor Garrett and his path-breaking scholarship, however, I do have some reservations about this particular project. To be sure, a large part of comparative law is looking at what is common and universal among jurisdictions. That common practice can, as Professor Garrett's project reveals, be a basis for minimum standards that can be embraced in international law. However, I have long expressed concerns that minimal human rights standards in the conflicted area of criminal justice could become maximum standards and actually have regressive effects. Comparative law is also about what is different. And here there are huge differences between the US and really all other countries. Following Eric Colvin, I would even say there are significant differences between the US and similar democracies like England, Australia, and yes, Canada. Let me say a few brief words about two countries that I'm hoping to include in my study. The first is China. There has been an explosion of writing in English about Chinese criminal justice, and there has been increased interest in wrongful convictions. One impetus for this has been the recognition of a few clear-cut wrongful convictions in the early 2000s, where murder victims literally came back from the dead. The cases attracted publicity and public concern and some government response in China. The People's Supreme Court in 2005 resumed mandatory review of death penalty cases. An exclusionary rule was introduced in response to the prevalence of false confessions obtained through torture, and both prosecutors and the courts issued guidelines to prevent wrongful convictions. Although the third part of the iron triangle of the Chinese criminal justice system, the police, did not. During this time in the early 2000s, I, like many, lectured in China about wrongful convictions. I have to say, though, that given recent events in Hong Kong and Xinjiang, I've come to regret this approach. I'm troubled that I may have made a small contribution to wrongful conviction washing, or an ability of a judicial system with no judicial independence and where defense lawyers can be punished criminally for doing their jobs, that attention to a few obvious cases of conviction of the factually innocent can help shore up and legitimate the criminal justice system. I leave it to you whether you would apply that also to democracies. Now I want to say just a brief word about India, because let you think that I'm becoming xenophobic in my regret for having lectured in China about wrongful convictions. I think that there is a lot to be learned from the Indian experience. As Carol McCartney and Clive Walker observed in a 2014 article in the Delhi Law Review, there have been frequent wrongful convictions in India, often involving police torture in terrorism cases. That said, what I find truly interesting is that the Law Commission of India, in a very thoughtful 2018 report, rejected an American-based focus on post-conviction relief for the factually innocent. It was not because they didn't say that there were wrongful convictions, but they did so because 2/3 of India's prison population in 2018 were under trials, i.e. those in pretrial detention. Today, the percentage is 3/4. The Law Commission of India defined miscarriages of justice to include unjustified prosecution and pretrial detention. This, in my view, is a good example of recognizing and responding to what is particular in a specific jurisdiction. But again, the particular is important. The Indian Supreme Court, for example, has not hesitated to overturn wrongful convictions on the basis of weak evidence. They do not defer to the jury on fact finding because there is no jury in India. They also award constitutional damages to the accused in a few cases while acquitting the at the same time as they acquit the accused. So again, context matters, but I'm optimistic that other democracies can learn from India's broader, albeit nascent and inchoate approaches to miscarriages of justice. So now turning to the topic, what can be learned from the English experience? My three commentators are far better qualified to comment on this than me, but here goes. Sometimes when someone from outside looks at your jurisdiction, you may see things that have just become obvious to you over the years. The first thing is the prevalence of guilty plea wrongful convictions. Now, of course, this is driven by the post office cases, but guilty pleas constitute 85 of the 466 miscarriages of justice on the University of Essex, very helpful miscarriage of justice website. But this number is reduced to 14 if the post office cases are excluded. It's also been reported in The Guardian, so it must be true, that 50 of the last 112 cases referred to by the CCRC since 2012 have involved guilty pleas, although this again may be dominated by post office cases. A Canadian registry that was co-founded by myself and Amanda Carling and will be launched on February 20th this year show that 15 out of 83 wrongful convictions in Canada resulted from a guilty plea. As in the UK, most of these are from a single controversy. But what is interesting is 75% of them involve either women, racialized, or people with mental health challenges. The American Registry of over 3,000 wrongful convictions has over 800 false guilty pleas, and that understates it because it excludes mass exonerations of the type that you are experiencing in the post office case and that we in Canada experience regarding Charles Smith, a discredited forensic pathologist. So what can be learned from these numbers? Well, this greatly expands the universe of potential wrongful convictions. Second, it appears in the UK and in Canada that those who overturn guilty plea wrongful convictions generally need some form of state assistance. In the UK, this appears to be from referrals from the CCRC and some agreements in some cases by prosecutors not to oppose. And of course, this assistance from the state is very important given that courts of appeal are especially reluctant to overturn guilty pleas because of their concerns about efficiency and finality, concerns that exist both in England and Canada. Now, of course, guilty plea wrongful convictions may be new news to those who study wrongful convictions, but it's old news to criminologists. English criminologists in the 70s were commenting on this, and indeed, the move to study wrongful guilty pleas is part of what Richard Leo criticized in 2005 as the lack of a criminology of wrongful convictions. But again, we can see that in some jurisdictions, guilty plea wrongful convictions have not been recognized as a problem. This includes, of course, India and China, but also I would suggest Australia and New Zealand. A central question is, how big is the iceberg of injustice that lies beneath the miscarriages of justice that are remedied? We also know that guilty pleas happen in England, even in the post office cases, despite attempts to regulate guilty plea discounts. In North America, they are often the result of what Deborah Turkenheimer has called lopsided plea deals, where people charged often with murder are made an attractive offer that is simply too good to refuse. So looking at guilty pleas, I think, is going to be a challenge for scholars and the media. So much our image of the wrongfully convicted are of the courageous who never admit guilt. I think it will benefit us all if we admit that the wrongfully convicted are sometimes those who give up and make rational and sometimes irrational, but often, unfortunately, rational decisions to plead guilty. Another lesson from the English experience is that a CCRC can be a mixed blessing. 7 Canadian inquiries from 1989 to 2008 have recommended that Canada create a CCRC, with the last inquiry in 2008 speaking in glowing terms of the CCRC as a needed inquisitorial element to the Canadian justice system and one that would aim campaigning that might bring the administration of justice into disrepute. As this audience will know, the bloom is off the English Commission. But the news has spread, I guess, less quickly to the colonies, including New Zealand, which created a commission in 2019, and in Canada, where it is expected the government will introduce a bill later this week to create a commission. Now here, I must reveal that I served as a research director for a 200-page report by retired Justices Harry Laforme and Juanita Westmoreland Chiori in 2001, commissioned by the Canadian government to set out design options for ACCRC. We used Zoom to conduct consultation with lawyers, Innocence Group, CCRA, and the wrongfully convicted themselves, not only in Canada, but in England, North Carolina, New Zealand, and elsewhere. We tried to address some of the weaknesses in the English model, but the devil is in the details and the funding. Now, as you may know, Canada retains ministerial review by the elected executive. One feature that Laforme and Westmoreland recommended be retained is that the Canadian minister has the option not only to refer a case for a new appeal, but to refer a case for a new trial, something that some of our English respondents found to be shocking, if not unconstitutional. We know that the Canadian system is quite reactive, and until recently only generated about 5 complete applications each year. That has gone up to 20, but still a fraction compared to what Scotland receives with a 5 times less the population of Canada. The English experience with declining representation of applicants, down from 30 up to 10%, convinced us that the applicants to a CCRC should be able, in appropriate cases, to receive funding, whether it be to be represented by lawyers or represented by legal aid clinics or in innocence projects. Professor Hoyle and Sato's work suggests that provisional reasons can be quite complex and require often legal assistance to effectively respond to it. I know that there are concerns that the CCRC has not been aggressive enough in its referrals to the Court of Appeal. And of course, the Scottish Commission stands as an example of a more aggressive commission, which when we looked at it only had a 50% success rate on its conviction referrals. But whether it be 70 or 50, both commissions are much more aggressive than the Canadian minister, who has referred 21 cases back to the court since 2002, and really all of them were winners. They either resulted in acquittals or, in one case, a reduction of murder to manslaughter. This, for me, raises what happens to the issue of unsuccessful referrals, because many of the critics of the CCRC say you got to be more aggressive. And of course, the Law Commission is going to be looking at the other side of the equation, which Michael Zander and others has, has said is the real problem. But one of the concerns is that without public reasons for the referral, if the Court of Appeal turns down a referral from a CCRC, is there going to be enough public debate to make the Court of Appeal and the legislature revisit or at least think twice about why the Court of Appeal has rejected the referral? I guess in some ways, the current project of the Law Commission, which is going to look at both the grounds for referral, the grounds for overturning convictions, and I think very importantly, the test for the admission of fresh evidence, which has been declining despite the recommendations of the Runciman Commission, suggests that that is possible. But it does raise the issue of whether public reasons, as some in the CCRC have expressed some desire, and the Westminster Commission recently recommended, could this generate a better and more informed debate about the barriers that are faced in overturning convictions and or the problem of the CCRC referring unmeritorious cases back to the court. Now, Canadian courts, in comparison to English courts, have been generous in admitting fresh evidence and will not enforce due diligence requirement over real concerns about miscarriages of justice. But because of an abundance of caution, Justice Laforme and Westmoreland Triori recommended that appeal courts be required to hear new evidence identified by our new CCRC or our proposed CCRC, but of course remain free, consistent with judicial independence, to determine what, if any, weight to attach to the evidence. And here, Justice Laforme's own longtime experience on one of our courts of appeal, we have 13 courts of appeal, played a role, because he says in most cases that's what happens. But why not kind of require that as a way of perhaps forcing courts to deal with evidence, whether it be about the suggestibility on false confessions or frailty of eyewitness identification or the rest. Now, unfortunately, we won't know until the end of this week whether the government has accepted this proposal or also accepted Justice Laforme and Westmoreland Triori's recommendation that safety and lurking doubt be added to the grounds in Canada for overturning convictions, which are like the 1907 grounds for your Court of Appeal, namely a miscarriage of justice or a unreasonable verdict that is not supported by the evidence. I can imagine in both cases that the judiciary will be would perhaps push back, and of course, given current climate concerns about crime in Canada, I'm not sure the government would introduce legislation that makes it easier for the accused to overturn convictions. Now, the biggest concern that we learned from England was, of course, the danger of underfunding. And I know that the underfunding is not limited to the Commission. It includes the dismantling of public forensic services in 2012, cuts to legal aid, and the like. But one of the astounding things for me as a scholar was to learn that the much vaunted independence of a commission, and we actually recommended that it not be called Criminal Case Review Commission because the wrongfully convicted told us, and Emily Bolton told us, we're not criminal cases, we're people, and we don't want a desktop review, we want an investigation. So the proposal is a miscarriage of justice come commission. But one of the, be careful what you want moments during the summer of 2021, for myself at least, was, as I said, the workload of the existing ministerial applications in Canada has expanded. I mean, still only 20 complete applications, but it has expanded by has expanded by a factor of 4. Budget has not been a problem because it is simply funded out of an almost $1 billion budget that our Ministry of Justice has. And we heard that there is no budget problem. Compare this to the New Zealand Commission, which thought it had an adequate budget, $4 million guaranteed for its first 4 years of operation, but then has quickly found that it is inadequate because it has been flooded by more applications than it has expected, and has actually only referred its first case just before Christmas. Now, the underfunding of the CCRC, to me, seems amenable to the tragic choices analysis used by Richard Noble and David Schiff in their 2000 monograph, and more recently applied in their work on the Court of Appeal and guilty pleas. Underfunding a commission essentially rations justice with often implicit concerns about finality, but without even the transparency that is provided by a Court of Appeal judgment, and also subject to very deferential forms of judicial review. One of the most disturbing things in the Hoyle and Sato excellent study is this idea that we're going to aim not to be Wednesday unreasonableness. That's a very low standard to set. Now, the Scottish experience, to me, also suggests that CCRCs are not only, as new criminal justice institutes, vulnerable to underfunding, but they're vulnerable to pushback from both the legislatures and the courts. And of course, there were some legislative acting up after the first Lockerbie referral. Some of that has been repealed, but it is a danger. But having said that, the commissions have endured, and they have become part of the criminal justice system. And we spoke with the North Carolina Commission, which is the only American CCRC, interestingly only limited to claims of factual innocence in felony work. They have a truly pathetic budget. Well under $1 million. They actually solicit funds on their public website and use grants tied to DNA testing. But yet, they have done some really good work, have reversed wrongful convictions, and using public powers have also found evidence that have allowed others to overturn their conviction. Their conviction. So, I'm aware and I'm interested to hear about the criticisms of the CCRC, but you're talking to someone in a jurisdiction where you really have to think hard about, is this a case of be careful what you want, or is this something at least to build on? Now, I also know that there's been debate in England about shedding jurisdiction over sentencing and perhaps minor cases. I would note, though, that New Zealand's first and only referral at the end of 2022 was a sentencing case where an offender was apparently sentenced on the mistaken basis that he was 17 years old and eligible for a harsher sentence, when in fact, the new evidence suggests that he's only 15 years old. I think it's also striking that North Carolina, in a much more punitive environment, doesn't have sentencing. And so I will be very interested to see whether Canada goes the New Zealand and English and Scottish route at the end of the week, or whether we are affected by the punitive environment in North America and decide not to include sentencing. Another lesson from the English experience is that the differences between what Dr. Naughton calls a lay factual innocence and a broader legalistic approach to miscarriages of justice with concerns about safety, rights, and legality are real, divisive, and can be dynamic. I tend to agree with Dr. Quirk that innocence is not the answer, at least for a commission and the court. However, I look to the 2014 amendments in the English compensation scheme to show how quickly these things can shift. And also the failed 2006 to 2008 new labor quashing convictions. So I think this remains a real and divisive debate. Innocence is, whether we favor it or not, a powerful political and social concept, even if proven innocence requirements undermine liberal criminal values that give the accused the benefit of a reasonable doubt and includes miscarriages of justice to include unfair trials. It is interesting that some of the most active American states on wrongful conviction are Texas and North Carolina. These are actually leaders in wrongful conviction reform, yet they are retentionist and highly punitive states with Republicans. Even you could go back to the Illinois experience where Governor Ryan also was influenced by a factual innocence model. And of course, in England, there are a few cases, Victor Neeland, and I think from what I've heard, Andrew Malkinson's case, fit in to the American factual innocence paradigm of wrong perpetrator DNA cases. But of course, many other cases will not be clear-cut. Another lesson is that 25% of the CCR applications involve sexual offenses. As the Australian scholar David Hammer has recently suggested, this is something of a dangerous third rail for both commissions and the innocent movement. A tricky issue in Canada will be the interaction of a new commission's work with restrictions in our criminal code on the production and disclosure of private records of sexual assault cases. It will be interesting to see what the Law Commission does in its ongoing project. It will hear requests to mimic Australian reforms and introduce a second and subsequent appeal when the interests of justice require the hearing of fresh and compelling evidence. This could be a safety valve or an end run around the CCRC and deferential judicial review of its decisions. That said, it places considerable burdens on the convicted person and is, of course, based on standards that the state imposes on itself when it abrogates double jeopardy, another erosion of traditional liberal criminal justice values. Having said that, the new appeal right has worked in a few Australian cases, but has generally been interpreted restrictively by the courts. Another issue is the Westminster Commission recommended to get rid of the discretion of the CCRC has not to refer a case, even if there is a real possibility that the sentence or conviction would be overturned. One of the issues for in Canada is, do we use a interest of justice test, as does the Scottish Commission, and indeed that is the entire New Zealand referral. And it seems to me that where Justice Laforme and Westmoreland Traore came down was to be skeptical of these kind of vague escape hatch clauses, even though we heard from the Scottish Commission that it is very useful and plays some of the same role as perhaps the unarticulated discretion not to refer case may be. Another lesson that can be learned from the English experience is the danger that reliance on the CCRC may diminish other legal and social measures to prevent and recognize miscarriages of justice. Despite Jon Robins' and valiant efforts, the investigative media is paying much less attention than before the CCRC. But I have to say, in Canada, even without a CCRC, our investigative media is not spending as much time as it used to on miscarriages of justice. This is related to the political economy of the investigative media and perhaps the temper of the times. And this is one of the reasons why on February 21st, we will launch our Canadian registry. It's not up yet, but it will be up at www.wrongfulconviction.ca. And one of the reasons why we have built this registry is not only to facilitate research, as is done with the Essex and American registry, but also to memorialize these cases so that they are not forgotten. In Canada, the sexual assault wrongful convictions have especially received no media publicity, unlike my impression in England. And I think part of this is because of the use of pseudonyms. It's very hard to get the public interested when the person is only known by two letters. And then finally, one of the perhaps perverse knock-on effects is of a CCRC is this overconfidence that you see in the Supreme Court in the Nunn case that the CCRC is a safety net. And again, I come back because I approach all my scholarship from a legal process perspective to the reality that CCRCs, like any executive agency, will make mistakes. That is inevitable, but they are only reviewed with increasing deference from the administrative courts. So finally, what have we proposed in Canada to kind of respond to the many ills of that are apparent with your CCRC? One is we have stressed the importance of funding. We have recommended that there be periodical independent reviews of the adequacy of the funding. I don't know whether that will work. We also proposed that the CCRC work collaboratively with innocence projects, that we don't want innocence projects, as they sometimes say in Canada, to go out of business once we have a CCRC. There needs to be sufficient funding to have a research and advisory committee, including on issues like forensic science, and also funding both for applicants' lawyers and to provide the sort of support that applicants need. Much will depend on funding, much will depend on appointments. Advisory boards can be dominated by campaigners, investigative media, or by efficiency and management experts. Not all CCRCs are the same. In conclusion, I hope to have convinced you that the comparative study of miscarriages of justice is a fruitful and necessary endeavor in a world where institutions like the CCRC and ideas like an international post-conviction right to claim innocence are migrating or trying to migrate to different parts of the globe. Thank you very much for your attention. I look forward to the commentators.
Kent, thank you very much indeed for such an insightful, comprehensive, geographically wide-ranging review, offering so many ideas there for us to consider. I'm going to invite each of our commentators to respond to your paper, if I can, before we take questions. And I'm going to begin with Henry Blaxland, King's Counsel. Henry has a CV that reads rather like a contents page for a textbook on appeals and miscarriages of justice. Many of the cases he's conducted in recent years include the high-profile, challenging and notorious cases. Sam Hallam, Pendleton in the House of Lords, a leading case on the test of safety. Derek Bentley of Craig and Bentley notoriety, Hickey, the Carl Bridgewater murder appeal, and many, many others. He is also the chair of the Criminal Appeal Lawyers Association, and I know from my involvement with them at their events, he is passionate about this topic. So we look forward to hearing, Henry, your response.
Yeah, thank you very much indeed, David, and thank you, Kent, for a very erudite talk. And I'm afraid my contributions are really going to fall well short of the standard which you've already set. And can I just start by saying that I'm afraid that I'm going to have to leave shortly after I've contributed, because I failed to consult my diary before joining the agreeing to join this event, and there's a memorial for my ex-head of chambers, Ian MacDonald, Queen's Counsel as he was, which I need to attend. And I just want to say something about him, actually, briefly, because it's relevant. People may know about Ian, but he was he's best known as the father of immigration law. But he appeared in 1970 in the Mangrove 9 trial at the Old Bailey, which was recently depicted in Steve McQueen's series on Small Acts, which many of you will have seen. And he helped to prevent what would have been a serious miscarriage of justice. So sometimes the system does work at first instance and saves work further down the line. Now, I have got I've selected five aspects of Kent's talk that I want to address, and I'm going to address them quite briefly. And they are these. I'll just go through them. Firstly, is the CCRC a good thing? Which I think is raised by the talk. Secondly, the right to claim innocence. Thirdly, the question of fresh evidence. Fourthly, and briefly, guilty pleas. And fifthly, and also briefly, compensation. Right, is the CCRC a good thing? Which is really, I think, the main question which is posed by your paper and what you've been struggling with in Canada for some time now. Well, Bob Woffington, who is an investigative journalist who I knew quite well, the late Bob Woffington, sadly late Bob Woffington, who wrote more than anybody on miscarriages of justice, firmly believed that the CCRC had become an obstacle to justice. I was going to say for good reason, but I have to say I'm afraid that I disagree with him. And I think we do need to start, if I may, by going back to the origins of the CCRC, just to remind everybody about it. I mean, CCRC came into being as a result of the Royal Commission of Criminal Justice's report in 1993, which came about as a result of a fundamental crisis in the criminal justice system, really triggered by a series of miscarriages of justice, which the Court of Appeal had failed to put right. In particular, the Irish cases, the Birmingham 6 case, the Guildford 4 case, Judith Ward, for example. Also, the Carl Bridgewater murder case was lurking there in the background, and it had become publicly recognised that something had gone badly wrong with the system. And that is why the CCRC was established by the Criminal Appeal Act of 1995. And that was a major breakthrough at the time, and was widely welcomed by those of us who practice in criminal law, and also by campaigners. There were some contributors to the Royal Commission who argued that rather than the Court of Appeal having jurisdiction to decide whether or not there'd been a miscarriage of justice, there should be a completely independent body. Interesting proposal, but one which was always going to be problematic in my view, because convictions can ultimately only really be quashed within the system. So it came about, of course, that the jurisdiction of the CCRC is simply to refer cases to the Court of Appeal. But I think it is worth remembering that when the Commission first started, it saw its task as really clearing out the Augean statements of past miscarriages, many of them depending upon false confessions, which themselves very often predated the Police and Criminal Evidence Act of 1985. Not entirely. The Cardiff 3 case was a case of false confessions, which were taped. That was the extraordinary thing about it. You could actually hear what the police officers were saying because they'd forgotten that they shouldn't be carrying on in the way they had been carrying on for so many years. But you only have to think of the Derek Bender case, which had enormous symbolic value at the time. I mean, Lord Bingham, in that case, took on not just the basis upon which the CCRC had referred the case back to the Court of Appeal, but took on the fundamental injustice in the case, which was the judge's summing up and the way the case had been conducted. And it gave rise to him referring to the right to a fair trial as the birthright of every British citizen, which is a memorable phrase and was emblazoned across the front pages of all of the newspapers at the time. The one point that I do think that we need to remember, however, and the one point that I think needs to be addressed, is that there came a time when the Criminal Appeal Act was amended by Section 14, subsection 4A, to provide that you could, in an appeal, it's no longer possible to argue grounds of appeal which had not been included in the CCRC's statement of reasons. Now, in the earlier cases, and Derek Bender is a very good example of it, and the Carl Bridgewater murder is an even better example of it, once the case was back in front of the Court of Appeal, the lawyers then got to work and conducted their own investigations. So in the Carl Bridgewater murder case, the case was referred back on the basis of a finding of a single fingerprint on the bike that was ridden by the newspaper boy, Carl Bridgewater. For those who don't know, Carl Bridgewater was the newspaper boy who stumbled across a burglary in a farmhouse and was shot through the head because he was a witness to the crime. The lawyers, in particular, the solicitor Jim Nichol, got to work on the case and had the confession evidence, which was the basis of the convictions, subjected to ESDA testing, which revealed, as had always been said by the person who made the principal confession, to have been fabricated. So the lawyers had a free hand, and the Court of Appeal have tried to put a lid on that now. I think because they had a bitter experience of one appellant who took up far more of their time than they wanted to, and they wanted to be able to put a stop to that. It was an unrepresented appellant. But it does mean that there is a restriction. You can get leave to argue grounds which are not in the statement of reasons, but I think it's, I think the lawyers need to be more proactive when conducting appeals. So is the CCRC a good thing? I think it is. There are problems with it, but I think we need to hang on to it. It's an asset which we need to preserve. Second topic, the right to claim innocence. I have a problem with this. Kent, you referred to Michael Norton's work, and there is, you're quite right, a tension between his approach to what the CCRC should be doing and what others of us think. For me, it is fundamentally important that what we're dealing with is a rules-based system which starts with the presumption of innocence. And as lawyers and dare I say it, as human rights activists, we need to focus on what needs to be done to improve the procedural rights which protect against miscarriage of justice. And that, of course, includes access to effective justice, which is why the whole question of resources and the funding of the criminal justice system is of such importance. So it's really, for me, it's about focusing on how we can improve the procedures and how we can, in the process, ensure that we minimize the number of miscarriages of justice that there are. Third topic, fresh evidence. You note in your paper, and for those of you listening, we had advanced copies of your paper, which was very helpful. You note a reluctance to admit new evidence. Well, fresh evidence and the failures of legal representation are the two most common causes of miscarriages of justice, or I should add to that, actually, non-disclosure as well. The issue of the approach to fresh evidence is one which has been a bee in my bonnet for many years. As David's pointed out, I was junior counsel in the House of Lords decision in Pendleton, which effectively challenged the earlier decision of the Court of Appeal in Stafford and Lavalio, but didn't overrule it. And that has caused a problem. And put it in very simple terms, the test that we were arguing for, and which Lord Bingham went some way to accepting in Pendleton, was that in a fresh evidence case, the test should be whether or not a jury acting reasonably may have acquitted, returned a different verdict, had the fresh evidence been available. The jury impact test, to give it its shorthand. In Stafford and Lavalio, the Court of Appeal in 1974 had rejected that and said it's not for us to apply the jury impact test, it's for us to decide for ourselves whether or not the appeal should be allowed, which came very close to the court deciding whether or not the appellant was guilty, as opposed to deciding whether or not the conviction is safe. And that is the point that Lord Bingham made. But since Pendleton, the authority, because he didn't overturn Stafford, it has effectively been, the authority of Pendleton has been eroded. And it has, and in a Privy Council decision called Dial and Dottin, rather sadly, Lord Bingham gave his, signed up to the majority opinion, which came very close to overruling his previous decision in Pendleton. He can't overrule it because it's a decision of the Privy Council. Can't overrule the House of Lords decision. But it, on the other hand, Dial and Dottin is frequently referred to. The fundamental illogicality of not applying the jury impact test completely baffles me. The Scottish courts in McInnes have the test. It was the test prior to Stafford and Lavalio. But this decision in Stafford and Lavalio was based upon the earlier decision of the Court of Appeal in the case of Cooper, which is the lurking doubt case. And in Cooper, the court decided that the new test introduced by the 1966 and following that the 1968 Criminal Appeal Acts effectively meant that the Court of Appeal had a subjective license to decide for themselves whether convictions are safe or unsafe. In other words, to decide whether or not they feel, because of some feeling about the case, that the defendant was wrongly convicted. Cooper was a difficult identity case, and of course, difficult identity cases were known to be a problem, and the solution eventually, of course, was the procedural protections which were afforded in the case of Turnbull further down the line. But Stafford approached Cooper as if lurking doubt could be translated into lurking certainty when it came to questions of fresh evidence, which to me is just fundamentally wrong in principle. But it does raise the question, which I think the Law Commission is going to have to grapple with, which is what is the role, if any, of lurking doubt? Is the Court of Appeal a court of review? I would argue that it is. And the solution is not to go back to lurking doubt. I think there are problems with lurking doubt. The solution is to pay proper regard to due process and to analyze weak cases and to find a basis, if there is a proper basis, for overturning convictions where there is a proper factual basis for doing so. And in fact, I had experience of that happening in a case in which the Court of Appeal did just that, but didn't in fact refer to lurking doubt. It was a case in which there was compelling evidence to show that the prosecution's factual analysis could not be correct. And yet the jury had been persuaded to convict. And the Court of Appeal accepted that on the factual analysis which we provided, that was right. And the conviction was unsafe, not because of any other procedural irregularity, but because that was the decision to which the court should have been driven. Effectively, that the judge should have allowed a submission of no case to answer. But I think that's probably the way forward. Sorry, I'm taking up far longer than I should do. My fourth point, guilty pleas. Can I just deal with this quite briefly, please? Kent, I think you'll find that one of the main reasons for conviction appeals being allowed, where there are guilty pleas, is because of wrongful advice by the lawyers. Okay, so to give you a good example of that, those cases in which the defendants are found to have been victims of human trafficking, but in which they have been advised that they didn't have a defence, and nobody sought to raise the question of their status as victims of human trafficking, have led to a number of convictions being quashed. I mean, I don't have the figures, but I think you'll find that is probably lies behind a lot of those cases. I'm disturbed to find that there are a number of cases in the post office Horizon systems sequence of cases in which people have pleaded guilty. I've not been involved in any of those, so I don't know what lies behind that, but that is very worrying. If that is, and that is the case, I'm sure that is very worrying that should have happened. I mean, the post office cases, I mean, are some of the most egregious miscarriages that I have ever come across, and there have been some bad cases, but just the breadth of it and the pig-headed obstinacy and dishonesty of the way in which the post office has conducted those cases, I mean, really makes the blood run cold. I mean, they're heartbreaking, a lot of those cases. Finally, compensation. Don't get me started, or I'm going to start myself. It is an absolute scandal, the failure of compensation. As David's pointed out, I represented Sam Hallam. I made, and I say this publicly in a recorded lecture, probably a fatal mistake in that case. So clear it was, so far as I could tell, that Sam Hallam was completely innocent, factually innocent, that I invited the Court of Appeal to record that on the basis that in a case called Adams in the House of Lords, Lord Judge had said that it's always open to the Court of Appeal to record a finding of innocence if they think that's appropriate. Adams was a compensation case about the definition of miscarriage of justice within the confiscation provisions. The court looked at me completely blankly, not knowing what on earth I was talking about, and declined to give Sam his declaration of innocence, and that was then used as a basis for refusing him compensation. Absolutely scandalous. And I don't mind who knows that I feel it's absolutely scandalous. Hallam and Nealon, of course, went to the Supreme Court on I'm afraid it's a very abstruse point, whether or not the compensation scheme violates Article 6, presumption of innocence. Read Lord Carr, the late Lord Carr's judgment in Hallam and Nealon in the Supreme Court. It's well worth it. He was pretty cross about it, but the appeal was refused. And we've been waiting for a very long time for the European Court to decide about it. The problem with it, actually, is that the legislation is just almost punitive. And the real problem is that in the 1990s, the discretionary scheme for granting compensation was abolished under a Labour government, as a matter of fact. But there it is. We need to distinguish between rectifying miscarriages of justice and compensating those who deserve to be compensated.
Henry, thank you very much. I can reassure you that was highly erudite, but also passionate and packed full of insights from your practical experience. So thank you very much. And thank you for speaking tonight when you obviously have important demands on your time as well. Can I turn next to Dr. Jon Robins, one of those very fortunate people in life who's had two successful careers to date. First as an award-winning investigative journalist, and now as an academic, a leading academic. But his focus has always been on the failings of the justice system, I think it's fair to say. And aside from his catalogue of impressive publications, both as a journalist and in academia, he also has the great distinction of having founded the Justice Gap web pages, the portal. And we're really fortunate, I think, as a society to have people as committed as Jon is to resolving miscarriages. And of course, we're very fortunate tonight to hear his views on Kent's paper.
Thank you, David, and thank you very much to Kent for inviting me, and fascinating to hear Henry talking as well. So I'm going to do my bit in two different parts. I'm going to introduce myself by reference to the first case that I wrote about and use that to highlight concerns about our criminal appeal system. And secondly, I'm going to identify some themes from a book I'm editing, to which Kent is contributing. The book's going to be published by Routledge later this year. It's called Murder, Wrongful Conviction and the Law, an International Comparative Analysis. And it features contributors from France, Spain, Netherlands, US, Canada, Taiwan, Argentina, Australia. I mean, I'm a journalist, I'm not a lawyer, I'm not an academic. My motivation is kind of a journalistic shock, really, at certain very problematic aspects of our justice system, and a desire really to know whether our jurisdiction is kind of uniquely, I had the word appalling written down here and I crossed it out and put dysfunctional. But having heard Henry talk about the Sam Hallam case and reminded me what an absolute scandal that was, I'm inclined to reinstate the word appalling. So the first case I wrote about was in 1998, and it was a case of Eddie Guilfoyle, a name I'm guessing will be familiar to a number of people here. He was convicted in 1992 for the murder of his heavily pregnant wife, and the prosecution case was, as accepted by the jury, obviously, that he faked her suicide. Paula Guilfoyle was discovered by Eddie Guilfoyle's brother-in-law hanging from the rafters in the garage. I'm not going to go into the details, it's really not relevant. My interest in the case was piqued 4 years later by a brilliant and explosive television investigation by a journalist called David Jessel on a programme called Trial and Error, which was Channel 4's version of Rough Justice. To my mind, the programme transformed a rather tawdry tabloid murder story into this thing, a miscarriage of justice. And David Jessel identified a witness who had actually spoken to Eddie's wife, Paula, on the day of the murder, at a point after which the prosecution argued that Guilfoyle must have murdered his wife. He also revealed shocking antics on the part of Merseyside police, including the possibility of their officers having planted evidence. And I've been writing about Eddie Guilfoyle's case pretty much ever since then. I've never seen anything that's pointed towards his guilt. I do acknowledge that some people are still convinced that he did it. My first article was published a quarter of a century ago this year. It was then, the Guilfoyle case was then the 14th case to have been referred by this brand new organisation called the Criminal Cases Review Commission. Eddie went on to spend, sadly, the Court of Appeal rejected what at that point in time seemed to be overwhelming evidence pointing to Guilfoyle's innocence. Eddie Guilfoyle spent 17 years in prison. When he came out, the momentum behind his campaign seemed unstoppable. despite the fact that he was banned from talking to the media under the terms of his licence. The Times newspaper joined that campaign, even publishing editorials on Eddie's case. One of the paper's big-name columnists, a Tory peer, Danny Finkelstein, went so far as to compare Eddie Guilfoyle, a Liverpudlian, to the most notorious French miscarriage of justice, Alfred Dreyfus. All to no avail. A fresh application went back to the Criminal Cases Review Commission, which did nothing for 7 very long years, and then rejected the case. In 2018, I published a book called Guilty Until Proven Innocent, and Eddie's case was the opening chapter of the book. The year prior to that, the Commission rejected Eddie Guilfoyle's last application. The Commission that year referred just 12 cases back to the Court of Appeal. So at that point of time, there's a prison population of around 87,000 people. Typically, every year, 1,500 people, mainly prisoners, were writing to the Criminal Cases Review Commission, requesting the Commission to investigate their cases. However, the watchdog sent just 12 cases back. The following year, it sent 13 cases back. The numbers have not recovered. They used to be around 33 referrals every year. That's an average over a 20-year period. They have significantly dropped. There is legitimate and growing concern about the crash in the number of referrals, and that led to a Westminster investigation into the watchdog, which Kent referred to before. The parliamentary group is chaired by Barry Shearman MP. So Barry has been concerned about these difficult cases for decades. And for example, he was involved in the campaign to overturn the conviction of a man called Tony Stock. That's another case that I've written extensively about. Tony, he died in 2013. He was convicted in 1970. He's one of just 2 cases that our Miscarriage of Justice watchdog has referred back to the Court of Appeal for a second time. A third application presently sits with the watchdog, and it's been there for, I think, 5 years. So there are huge concerns about the Commission's willingness to take on an increasingly conservative Court of Appeal. The Westminster Commission went on to report that of all parts of our neglected justice system, the part that's been hit hardest has been the safety net set up as a result of cases like the Birmingham 6 and the Guildford 4. The Westminster investigation reported that the chair of the organisation explained the scale of the cuts thus, and it was kind of taken from an interview that I did with the CCRC chair called Richard Foster, and he told me that for every £10 that the organisation had 10 years ago, it had just about £4 at that point in time. So the scale of these cuts are astonishing. According to the Westminster Commission, it's revealed that its caseload has doubled since 2010. An area of concern I share with Hannah, which is also flagged by the Commission and mentioned by Kent, it is the independence of the watchdog from the Ministry of Justice. I don't know what Hannah's going to say, and I don't want to kind of trespass too much, but I just want to take the opportunity to point out that we found out last month that the chair of the Miscarriage of Justice watchdog is also going to be running the Judicial Appointments Commission. Apparently no one sees a conflict of interest, not the judiciary, who identified the chair as their preferred candidate, nor the House of Commons Justice Committee, who rubber-stamped their decision. It's really great to see our Canadian friends have read the Westminster Commission report, perhaps more closely than some people closer to home. So that's the kind of backdrop for my interest, and explains what led me to editing the book that Kent has very kindly written a chapter for. I'm going to identify some themes very briefly, and I'm going to thank Jago Russell, who's the former chief executive of the charity Fair Trials, whose chapter I'm about to rip off, frankly. Nonetheless, first of all, it's striking, but it's perhaps not surprising how much we have in common with jurisdictions around the world, whatever the legal system. And that's nothing to do with kind of our success, if that's the right word, exporting our adversarial justice system, but the innate fallibility of the courts that we, I think, do appreciate, juries, and kind of this sense of institutional defensiveness. The first point that Jago makes in his concluding chapter is quite rightly to draw attention to the devastation of wrongful conviction on people's lives. So readers will find out about Cristina Vázquez in Argentina, who, given life and murder, tragically took her own life by the time her name was cleared. In Taiwan, Chiao Ko-ching was eventually acquitted of rape and murder of a 5-year-old after having been convicted on the basis of confessions dictated to him, having been tortured and interrogated for 37 hours. By the time he had his name cleared, he was executed. Closer to home, Henry reminded us about the terrible case of Sam Hallam. I mean, I interviewed Sam shortly after he was released from prison, and you know, the damage done is extraordinary, and we know it's profound. There's been lots of research done on this. He was released from prison with no compensation, having had his life ruined. His father took his own life because he blamed himself for his son's predicament. The way Henry set out, the Court of Appeal dealt with that, just beggars belief, and it's well worth finding out more about that, really. In 2020, I submitted a Freedom of Information request to the Ministry of Justice, which revealed in the last 5 years, there have been just 5 compensation payouts made to people wrongly convicted, a total of £10,000. Not a single penny was paid out in the last year of that period. To put this in context, in a 2-year period from 2007 to 2009, the Ministry of Justice paid out £21 million. And I think the compensation point is totemic of where we're at, I think. So a final series of kind of headline points that Jago drew my attention to. He talks about those who suffer most from miscarriages of justice tend to come from the most marginalised people in our society. So in New Zealand, the Maori account for 53% of prisoners that make up only 16%.
John, I think we're getting sort of intermittent sound, I'm afraid. What I'm going to propose is that we pause on your comment and turn now to Hannah. In case we lose you, can I just say, we already had lost him. I was going to say, thank you in particular for raising the Guilfoyle case, which is a case, funnily enough, that I was lecturing on only last week, and one that I still find fascinating. Our final commentator, Dr. Hannah Quirk, who is at King's College, I've worked with for several years on various projects, and I know from that how deeply her expertise runs in relation to appeals and miscarriages. That's not surprising. She, in fact, worked at the Criminal Cases Review Commission shortly after her doctoral work, and she's researched and written extensively since then on this topic, as you know. And I think she's one of those rare lawyers, in this jurisdiction at least, who's bridged the gap between academia and practice. She has influence on the judiciary, lectures to the Judicial College, lectures to practitioners, is a fellow of Inner Temple, and contributes to the Crown Court Compendium as well. So extremely well placed to comment on practical and academic aspects. Hannah.
Thank you, David. I'm conscious of time, and I know you want to leave a bit of time for audience questions, so I'll keep my comments brief. Kent, thank you for a fascinating paper. My interest in this work in a comparative way began in 2005 when I left working the Criminal Cases Review Commission and had a British Academy funded project to look at the Innocence Project in New Orleans. And I had this lovely idea of comparing the two jurisdictions. And after about 20 minutes in the office in New Orleans, realized there really was no comparison between what was then a reasonably well-funded government body with statutory powers to access materials and interview people, and a project where the building was being eaten by termites, was flooded by Hurricane Katrina, was run by student volunteers. So I really took your point about the benefits of looking at your own system from a different perspective. I think one of the really frustrating aspects of miscarriages of justice work, Edwin Bouchard wrote in 1923 about the canonical causes of miscarriages of justice, non-disclosure, confession evidence. They really haven't changed since then. I mean, we're just kind of reinventing the wheel, and there's been like a willfully slow learning process that every jurisdiction has to have its own cause célèbre, years of people plugging away trying to achieve reform, and then there's this brief window when things seem to align. A case is so shocking it cuts through to the public. And I think one of the lessons from the English system is that it takes years of failed efforts to get reform, but people need to be ready for that very, very short moment, in our case after the Birmingham 6, amongst other cases, when public opinion was so horrified by what was happening. And I think the post office scandal gives us again a similar moment, that it's really cut through into public consciousness. And if we're going to achieve any kind of reform, now is a very opportune moment, which is unlikely to withstand the vicissitudes of a general election and Labour reverting back to its tough on crime type mantras. That's always going to be more of a vote winner than defending miscarriages of justice. Scholarship has become much more diverse since 2005. I think one of the difficulties has been the distorting effect of the American scholarship on the subject, that all this kind of work is viewed through the American prism of innocence. And I think that's actually been quite unhelpful, certainly in this jurisdiction, because we have so few cases of clear-cut innocence. I know people who've worked on cases such as Jon and Henry are convinced of the innocence in these cases, but in terms of proving that to the standard that will satisfy the Court of Appeal, it's an extraordinarily high bar. And I think our safety test is less exciting, but is much more protective of individuals. I thought your concept about miscarriage of justice washing was a very interesting one, and that should we be window dressing oppressive regimes? I think changing the law in books is important. The law in action is obviously a very different matter, and I think that's been an issue in this country as well, that we have a law that allows the Court of Appeal to quash far more convictions than it does. But Stephanie Roberts has written repeatedly about it's the court's intransigence in many of these cases is the issue rather than the wording of the statute. And similarly, that some of the disappointments of the Criminal Cases Review Commission, I think, are much more down to a culture and an attitudinal problem rather than its powers. I absolutely take your point about funding and legal representation. I think they're important, but I think the organisational culture is what's absolutely critical here, and something that's changed very much since I was working there. The benefits of scholarship, I think, are invaluable in this area, and I think your idea of comparing jurisdictions is very important. Something I also think is important is the need to examine how things change over time. I think some of the work that the Exeter University have done around issues around guilty pleas, for example, or confession evidence, it's changed enormously in this country since the Police and Criminal Evidence Act came into effect, that the idea of police beating confessions out of suspects is pretty much unthinkable now. And I think comparing cases over that longer period of time can actually give us quite a distorted view. The post office cases, I think, are very exceptional, and it might be worth analysing separately to the current cases. I think one of the really interesting aspects of talking about this work, and I found the conversations we had with your group on setting up a Canadian system was fascinating, how other countries propose to do things and looking critically at our own work. I think it demonstrates the need to be vigilant, that we can't just say, well, we've set up this commission, we can sit back, everything's fine. There's a huge benefit in exchanging ideas, reinforcing the good work that's going on in other countries, being critical friends to that kind of work as well. International pressure was absolutely critical in getting the conviction of the Birmingham Six overturned. The attention, particularly from the United States, that was given, and the pressure that was put on the governments. I think that international pressure now is still as important in how we examine each other's systems and reflect on our own. And I'll leave it there.
Hannah, thank you very much. Jon, can I invite you back so that you could complete?
Hi, I can hear you. I think I'm okay, really. I was kind of getting towards the end, and apologies for kind of dipping out. I mean, I think I'll just endorse one of Hannah's points, and and I hope the Canadian experience kind of deals with some of these more difficult issues. But when she was talking about the problems of the culture of the Criminal Cases Review Commission, I was reminded of a great quote from David Jethel, who I mentioned before in the context of presenting the trial and error on the Eddie Guilford case. He then became a commissioner at the Criminal Cases Review Commission, and he had this wonderful kind of slightly over-the-top turn of phrase when he was describing what the commission in its first incarnation embodied. And he talked about the nationalisation of zeal and the taking of passion into public ownership. And what he was saying was actually the commission in its first incarnation was driven by campaigners and driven by people with a desire to overturn convictions and to right wrongs. And I think, you know, that spirit somehow has to be maintained. And it's obviously it's not an easy thing to do, but that's the challenge. And I think that's one of the difficult issues to discuss about the commission here.
I don't know if you heard my thanks when we lost you, but I was saying how grateful I was that you raised the Guilfoyle case. It's one that I continue to be fascinated by, and I think anybody who reads that, and not only is the law report, but also the press and other interest around that, will be fascinated by it as well. We have a few minutes left, and we've got at least three questions in the Q&A. So I don't know if they're visible to everybody, so I'm going to read out the questions and then invite any of the commentators to address them. First comes from Irene Mansfield. Would you agree that certainly in England, if not in the rest of the UK, the lack of legal aid leading to defendants being advised and represented badly, and our courts being so behindhand, leading to long adjournments and delays, contributes to miscarriages of justice? I think I can predict an answer from most people on that. Hannah, would you like to comment on that?
Absolutely. I wouldn't necessarily say bad representation, but lawyers are under enormous pressure. I think there's less time for things like searching through unused material, which is where we know so many miscarriages of justice happen. It's more the lack of time to do that kind of investigatory work. The delays are obviously not ideal in terms of witness, how fresh their memories are and things, but I think the difficulty is the burden that's being placed, actually not just on defence teams, but also Crown prosecutors and police officers as well. They've had awful cuts to their budget. I think everyone's trying to do too much with too few staff. It's bound to lead to mistakes.
Anybody else contribute on that particular question? Can I see John?
Yeah, I mean, there's another issue about that. I mean, I've spoken to many families who spent tens of thousands of pounds, remortgaged their houses, paying for legal representation, which they've been deeply unhappy with. So there's an exploitation element as well, especially around historic sex cases. You know, you routinely hear of people, families who will do anything to get their loved ones out of prison, but, you know, spending £30,000 just to begin a relationship with a solicitor who ultimately is not going to help them, really. Often that's the sad reality of it. So yeah, I think that it's a difficult issue that needs to be unpacked.
And even if they are acquitted, they don't get their legal aid reimbursed. It's only reimbursed at publicly funded rates rather than the private rates they've had to pay.
Yeah.
Can I turn to the second question, which I think is a very good one, and I'd invite comment from all of the panel on this. This again from Irene Mansfield. You're all talking about the big egregious miscarriages, but I worry about the routine small examples resulting from the above factors, as well as what I see as the weakening of the presumption of innocence in juries, the ease of pleading guilty, etc. And I think that's really borne out by some of the post office cases, as Henry mentioned. Some of those, they might have been summary only cases. They might have been apparently low level in that sense, but they are destructive of lives. So anybody going to pick up on that? Kent, did you want to add to that?
Sure. I'm struck by what Hannah said about the post office cases providing an opportunity for further law reform, because, you know, as I said, we really need to think about why people make these often pleas of guilty rationally. And, you know, certainly in Canada, we found women to be very overrepresented, racialized people to be overrepresented. But I think the media also has to, I mean, so much of our, so much of our past with wrongful convictions have been those who have bravely maintained their innocence. And I think a real challenge going forward is, how do we express empathy for those who give up and are, you know, making a rational decision, as those with the post office case, and that they need help. And the CCRC help, again, to go to one of Hannah's points, has to reflect what the evidence now and in the future will be, which is going to be more about, video and algorithms and evolving science than it is about, the old form of third degree or torture and false confession. So I think that those are cultural challenges as well.
I think that's why the post office case is so important. I mean, I've been talking about, the Birmingham 6 was the cut-through example previously, and then I realised, that happened before most of my students were born. I think the post office is a very vivid example to people of why, if you are faced with what appears incontrovertible computer evidence, and you will go to prison if it goes to trial, it's very easy for people to see why somebody would plead guilty. And the fact that they're all people of previous good character, the fact that postmasters and mistresses hold quite a special place in community life, it's much more easy to be sympathetic to people like that than people who probably were involved with terrorists anyway or have a slightly dubious background. So that's why I think this case is so important, because it's an exemplar of how we can drive criminal justice reform with very sympathetic examples. For the first time in ages, I've had people who understand what I'm researching. Oh, I read this stuff about the post office case. Have you seen it? It's really cut through to the public in a way which I can't think of a case that has done in previous 25, 30 years.
I'm conscious that Jon has to leave us shortly. I don't know if you wanted to contribute to that question before you have to leave, Jon.
Sorry, yes, I do have to go. On the post office case, one of the reasons why it's gained such kind of massive attention, it is by virtue of the fact that the people are, the people involved are sympathetic, and people can kind of relate to this idea that your life can get flipped around because of a glitch in a computer program. I think that's easily to relate to. One of the problems with, from our point of view, is really it's atypical as a case, so it doesn't have many of the features that kind of we really do need to thrash out. If you don't mind, I'm going to have to dip out at this point, but thank you so much, Kent, for inviting me, and apologies for kind of my dodgy connection, and look forward to catching up with you at a later date. Thank you very much.
Thank you, Jon. Thanks very much. I'm just going to deal very swiftly, if we can, with the last couple of questions. I'm conscious of the time, and I know that we were advertised finishing, but we just have 2 questions remaining. First, from Roach, evidence retention is also a real issue for those of us investigating miscarriages of justice. Inside Justice, the charity I work for, has a couple of cases where police have either lost, destroyed, or won't disclose what evidence they have. Do other jurisdictions have different, my machine has now lost me the text, have differing protocols around evidence retention and access to exhibits? Ken, can I pose that question to you?
Yeah, I mean, the problem is even greater in Canada because we have divided jurisdiction and each police force has their own. We do have public forensic services, so that helps to some degree, but I agree that that's a critical issue. We tried under our charter, our Bill of Rights, to declare that there was a right to retention, but the court said that's a legislative task and the legislature doesn't want to do it because it's not a priority.
Thank you. Hannah, I don't know if you have anything you wanted to add to that. Okay. Can we move on then to Louise Shorter's question, which I think is another fascinating one. Professor Zander wrote last year that the Law Commission should seek to interview Court of Appeal judges, serving and recently retired, as part of its forthcoming review. Does the panel agree that this would be fruitful? Do appeal judges tend to agree to this sort of review in other jurisdictions? Again, perhaps we could start, Kent, with your view.
Yes, well, we had a retired Court of Appeal judge, Fred Kaufman, who chaired a public inquiry that I was involved with into a wrongful conviction. And he recommended in 1998 the lurking doubt standard be enacted. He did say, based on 18 years of experience on a Court of Appeal, that it wasn't a guarantee, but he thought that his colleagues needed more prompting. So I think that there is something to be said. It should also be noted that 2 years later, a unanimous Supreme Court in a judgment written by Louise Arbour rejected the lurking doubt standard as too subjective. So that's one idea that hasn't made it over this side of the Atlantic yet.
And Hannah, I don't know if you wanted to add anything to that. You have a view?
Just quickly, I think it's notable the Court of Appeal is the only aspect of the criminal justice system that's never reflected on its role in miscarriages of justice. We've had significant reforms from the police, Crown Prosecution Service being established, defence solicitors improving their behaviour. The Court of Appeal has never, to my knowledge, acknowledged its role in any of these cases. I can't see it would do any harm to interview them, but I think there appears to be a lack of reflectiveness amongst certain members of the judiciary, present chair excluded, obviously.
On that note, perhaps we better draw things to a close. I'm conscious of the time, and I know there are a couple of other questions there, but I'm really grateful for everybody who's spoken this evening. The zeal to choose to draw upon Jon's word there is so evident on this topic. Thank you to Kent in particular for providing us with that fantastic paper as a springboard for all of the comments that followed. Thanks also to my co-director, Mark D'Souza in the Criminal Law Centre, who was instrumental in setting up the whole event. And finally, thank you to Lisa Penfold, who arranged the smooth running of the Zoom and recording facility so that this will be available for people to view online in due course. And thank you all very much again for joining us at the UCL Criminal Law Centre event.
Thanks.